Good morning. My name is Simon Passfield and I'm the head of the insolvency team at Guildhall Chambers. Thank you for joining us today for the first of two webinars considering the new Corporate Insolvency and Governance Bill, which is expected to receive word assent next month. In this first part of the webinar, we will be providing an overview of the key amendments and highlighting some of the practical consequences of the bill. In the second part, which is taking place at 2 o'clock next Wednesday, our colleague Sam Parsons will be joined by Robert Niles-Weed of Weil Gotshal and Mange's New York office, and they'll be discussing the long-lasting effects that we might expect to see from the legislation, comparing and contrasting it with the legislation Chapter 11 on the other side of the Atlantic. At this stage, I would like to introduce my co-presenters today. Firstly, most of you will know Stefan Ramel, who's a senior member of our insolvency and commercial teams.
Good morning, everybody.
And I should say, while you may know Stefan, you may not recognise him with his new facial files that he's been growing over the course of the lockdown. We're also joined today by Govinder Chambay, who is a Second Six pupil in Chambers, specialising in insolvency and commercial law.
Good morning.
Before we begin in earnest, there are three items of housekeeping. First, can I just ask people who are participating on this call to remember to switch off your microphones and webcams. That avoids you suddenly popping up on screen inadvertently or there being any interference or background noise whilst we're presenting. And secondly, in a similar vein, can I please ask you to refrain from taking control of the PowerPoint slides, otherwise there's a tendency for things to go a bit haywire. Finally, if anyone does have any questions as we go along through the course of today, then please feel free to raise them using the chat function, and we'll then endeavour to answer them at the end of this session. Alternatively, if you have any questions you'd like to store up and raise orally at the end, then please do so and we'll do our best to answer them. So with that introduction out of the way, I'm now going to hand over to Stefan, who's going to start by outlining the background to the new legislation.
Simon, thank you very much, including your gracious comments about my lockdown beard. Ladies and gentlemen, a very good morning again to you. In terms of how we propose this talk to flow, I am first of all going to look at the moratorium restructuring plan and ipso facto clauses before handing over to Simon, who's going to address you on winding up petitions, and then Govinder, who's going to address you on wrongful trading. At the end of the webinar, I'll return to speak about the Henry VIII clauses, which are included in the bill. My part of this talk is really an overview of the permanent changes which are going to be introduced by this bill. So you might think of this as a bit of an amuse-bouche for part two of this webinar, which is taking place next week, or if you're watching the recorded version of this webinar, you can watch immediately afterwards, of course. It's probably appropriate to include a health warning at the start of this webinar. The bill, which is the subject of our talk, has not, of course, become law. It is, of course, subject to future amendment, and so its content and drafting may evolve over the coming weeks. For example, I know that at yesterday's debate in the House of Lords, many lords spoke on the bill and indeed indicated an intention to table amendments today. However, what will hopefully at least not evolve is the broader factual matrix or context in which this bill is being brought forward. And so that strikes me as a good place to start by way of a scene setter, which is really the genesis of this bill. So although you might be forgiven for thinking that this bill has rushed up out of nowhere in the middle of a pandemic, in fact, as the slide on screen shows, the permanent changes which are being introduced by this bill which held some time ago, starting in 2016. In my view, at least, that means that when inevitably there will be difficult issues of construing provisions in the bill in coming years, and I'm sure there will be. I've seen Simon and Govinder's slides for this webinar and Sam's slides for part two of the webinar, and it's fair to say the bill leaves lots of questions unanswered. However, as things stand, there is a lot of material out there which will hopefully facilitate an understanding of how we got to where we are and to provide the context. So in terms of the consultations, there were two consultations, and I'll come to those in a moment, one in 2016 and one in 2018, before an EU directive in 2019. Now, it might be thought that the lag between 2018, the last consultation, and 2020, the introduction of this bill, is readily explicable by the other major piece of business which has been occupying the government prior to this pandemic. But what's less clear is over what period of time the bill, which is presently before the House of Lords and which was introduced into the House of Commons, was drafted. On any view, it is a lengthy and complex bill. It runs to, at least in its House of Lords incarnation, 240 pages. It's been drafted. If it's been drafted in recent weeks, that really is an incredible feat. The likelihood, I suspect, is that the gestation for the bill has been longer than that. Let me say a few brief words then, by way of context in relation to the consultations. And it's interesting to note what was proposed in the consultations and what has made its way into the bill and what hasn't. The first consultation was called a review of the corporate insolvency framework. It ran from May to July 2016. And the drivers for this included principles established by the World Bank, by UNCITRAL, but also moves afoot in Europe. As Sajid Javid, who was the then Secretary of State for Business, Innovation and Skills, said, and should the worst happen to a business, we have a duty to give it the best possible chance to restructure its debts and return to profitability while protecting its employees and creditors. And it might be thought, and I'm aware, of course, there's a lot of material out there on this bill, that the protection of the business may take more centre stage than protection of employees and creditors, but that's a matter for debate. The four matters included in the consultation were a moratorium, a proposal described as maintaining contracts, although it's presented then in a slightly different way than it is now in the bill, a flexible restructuring plan, and as number 4, options for rescue financing. Now, it goes without saying that the reforms are really intended to affect corporate insolvency. There is nothing in the bill on personal insolvency, and indeed, as the bill suggests, that is not its scope. The consultation attracted a lot of interest. There were 2 roundtable meetings, 71 responses, and indeed the government's very much inverted commas, summary responses document, which I looked at yesterday, but which was prepared after the consultation closed in 2006, runs to 663 pages. The moratorium was strongly supported, as was the proposals on essential supplies, and the same for the restructuring plan. Rescue finance, however, did not attract strong support, and indeed it was recorded that the responses to the consultation indicated that a lack of finance rarely prevented the rescue of viable businesses. The existing framework did enough to permit rescue financing. By 2018, the scope had moved on a little bit, and this second consultation, Insolvency and Corporate Governance, was axed far more on the boardroom and good governance. Also strong participation, 93 responses. And here it's interesting to note that after that consultation had closed, the proposed outcomes included the government taking forward measures to ensure greater accountability of directors in group companies when selling subsidiaries in distress, legislating to enhance existing recovery powers of insolvency practitioners in relation to value extraction schemes, legislating to give the insolvency service the necessary powers to investigate directors of dissolved companies when they are suspected of having acted in breach of their legal obligations, and also, it said, creating alternative procedures to support business rescue. Now, it will be evident from the title of the bill and from a slide in a couple of slides' time that it is really the latter which has made its way into the bill, and the other areas of focus, according to this consultation, are not being taken forward at this time. Lastly, but by no means least, I ought to mention briefly the EU directive on preventive restructuring frameworks and on the discharge of debt. This was adopted by the European Council on 6th of June last year, so just over a year ago. It came into force on the 20th of June, and in other European countries it's due to be implemented in 2021. Although, of course, unlikely to be strictly relevant to the UK, that's not to say that we shouldn't be aware of it, mainly for this reason, or at least 2, I suppose. One is that it means other European countries will be introducing their own systems, and that will mean competition for whatever, or in relation to whatever restructuring is introduced by this bill. And I know, for example, that the Dutch have prepared to launch their own variant of a scheme of arrangement, which on 26th of May 2020 was passed by the Dutch lower chamber of Parliament. It's called an Act on Confirmation of an Extrajudicial Restructuring Plan, and it's expected to be law by the early July. So other European countries will be introducing these measures, and that leads to the second benefit. There may well be some learning, and I know that Sam to some extent builds on this in part 2 of this webinar by comparing somewhat to the US experience. There will be a resource out there in terms of what other European countries are doing in their jurisdictions for schemes and moratoria and so on. But to return to the directive, and just to see quite how much overlap there is with what's in the bill, Article 4 of the directive requires member states to ensure that if there is a likelihood of insolvency, debtors have access to a preventive restructuring framework that enables them to restructure whilst protecting jobs and so on. It goes on for the debtors to remain in possession and for a stay of individual actions. And in connection with stays, it also says at Article 7 that member states have to ensure creditors are not allowed to withhold performance or terminate, accelerate, or in any other way modify executory contracts. Executory in the context means something different to what we would understand as executory, to the detriment of the debtor. So in other words, ipso facto clauses. It also provides at Article 8 for cross-class cram-downs. So as I indicated, it's readily obvious from just cantering through those couple of provisions in the EU directive that there is substantial overlap with what's in there and what is in this bill. That brings us to the present day, and on the next slide you will see how it was trailed by the Business Secretary, Alok Sharma, on the 28th of March, during which he said that the overriding objective of the government is to help the UK companies which need to undergo a financial rescue or restructuring process to keep trading. The measures are designed to give those firms extra time and space to weather the storm and be ready when the crisis ends, whilst ensuring that creditors get the best return in all possible circumstances. Now, if we then move on to the next slide, you will see the parliamentary timeline. The bill was published and had its first reading in the House of Commons on the 20th of May. Its second and third readings were last week on the 3rd of June, and on the same day it was introduced to the House of Lords and had its first reading there. Its second reading, as I've indicated, was yesterday, and it generated numerous interventions by Lords. The third and final reading in the House of Lords, I understand it, is penciled in for the 23rd of June, and as Simon has already indicated, it's expected to become law by the end of June or early July. Now, in terms of the overview, or an overview rather, of the bill, you can see that it's really broken up into 4 areas, 2 of which we're touching on this talk, and the first one Sam is touching on in more detail in part 2 of this webinar. First of all, the permanent insolvency measures, moratoria, arrangements and reconstructions, termination clauses, winding up petitions and suspension of liability, and then corporate governance measures, which we're not really addressing in this webinar, but which look at matters such as virtual annual general meetings for companies and pushing back filing deadlines in relation to annual returns, confirmation statements, and so on, before finally delegated powers and Henry VIII clauses. We've given you the section and schedule cross-references to the bill as it currently stands. That brings me then to moratoriums. And as I say, and I repeat, what I say now is not intended to cut across Sam's talk. So really only a couple of points on this. The first and most important point, in my view, on the new moratorium is that it's intended to be a standalone process. It could, for example, be a precursor to a CVA or to a new plan, but of course it doesn't have to be. The moratorium will be available to all companies, except financial service companies, and also companies, of course, which are already in an insolvency process. In terms of entry routes, the bill envisages an out-of-court and an in-court entry route, depending on whether a winding up petition has been presented against the entity. The out-of-court route requires directors to file a notice at court, along with a statement that the company is or is likely to become unable to pay its debts. A statement from an insolvency practitioner, referred to in the bill as a monitor, that in the monitor's view, the moratorium will result in the rescue of the company, not the business, as a going concern. And note also that whilst the coronavirus pandemic is with us, that requirement is tweaked somewhat to say that it would be able to do so were it not for the pandemic. The moratorium has an initial duration of 20 business days. That can be extended with no need for creditor consent by a further 20 business days, or it can be extended to a period of 12 months, but that requires creditor consent or a court order. In terms of the substantive consequences of the moratorium, it is that there is a payment holiday for pre-moratorium debts, say for certain specified debts. So, for example, the monitor's remuneration doesn't attract a payment holiday, and then ongoing rent, for example, or ongoing wages, goods, services, which are supplied during the moratorium, are also not subject to a payment holiday. The moratorium is intended to prevent enforcement, insolvency proceedings, enforcement of security by secured creditors, and other legal proceedings too. The monitor is plainly going to have a crucial role because the entry and any extension of the moratorium is overseen by the monitor. The debtor, however, and the directors remain, so the jargon goes, in possession. Note also the moratorium can be brought to an end if, for example, it ceases to be the case that the moratorium will result in the rescue of the company. Let me leave the moratorium then and come to look at the restructuring plan. The plan is intended to operate much as schemes of arrangements do now, and it also has some similarities with CVAs, although of course the plan will be able to affect secured creditors. The expectation, however, is that case law on schemes will have some obvious relevance in the interpretation of the plan. In the same way I did for the moratorium, in terms of which companies are eligible to propose a plan, it's any company able to be wound up under the Insolvency Act. The statutory gateway, or at least the gateway in the bill, involves two matters. First of all, that the company has or is likely to encounter financial difficulties, is the phrase. And secondly, that the moratorium, the proposed compromise with creditors or creditors and members, will eliminate, reduce, prevent, or mitigate the effect of the said financial difficulties. The moratorium process is designed to be very much like a scheme. So that is, it will require an application to court for the court to direct convening of meetings of creditors or classes of creditors. Said meetings then to take place, or meetings of classes, with the voting majority being 75%, with the possibility of the court, or rather the requirement of the court then sanctioning the plan. The moratorium will be in a new Part 26A, and importantly, and this is a major difference with schemes of arrangement, it will include a cross-class cram-down. In other words, even if there are dissenting creditors, the court can still sanction the plan. There are two requirements for that. First of all, that the court is satisfied that members of any dissenting class would not be any worse off in the event of the relevant alternative, and that's what the court considers would happen if no plan was sanctioned. And of course, as one might expect, there will be difficult issues, for example, of valuation as to whether the business is valued on a breakup basis or a going concern sale basis, and that will affect this assessment. The second criteria is that the compromise has been agreed by at least 75% in value of a class or class of creditors or members who would receive a payment or have a genuine economic interest in the event, of the relevant alternative. Finally, by way of this introduction into the permanent provisions, let me move on to ipso facto clauses. The bill proposes to introduce a new section 233B into the Insolvency Act, which will be engaged where a company is subject to a relevant insolvency procedure. That means moratorium and administration, the appointment of administrative receiver, a CVA, liquidation, a provisional liquidation, or indeed a plan. The new section then provides that any contractual provision which envisages the contract terminating, and then two phrases of great width, or any other thing which could take place, or the supplier being able to terminate or do any other thing, ceases to have effect. So first point to make is which contracts is this going to apply to? Well, the contracts for the supply of goods or services. Next, and I've already observed that the drafting of the two phrases in the bullet point is very wide indeed. So, of course, it includes termination, but might also include varying payment terms, so acceleration clauses, but also things like default interest. It plainly intended that the consequence of the new section is that suppliers will have to continue to supply goods and services despite an insolvency. When this was originally proposed back in 2016, the consultation envisaged that the debtor company would have a system of designating key or important suppliers, but as you can see, that hasn't found its way into the bill. That there are exemptions, companies which are involved in financial services, for example, banks and lenders. The supply contract can be terminated, but only in certain restricted circumstances if the officeholder or the company consents, or the court is satisfied that the continuation of the contract would cause the supplier hardship. I would expect there to be litigation around how one demonstrates hardship and how one comes within that wording. Finally, the supplier cannot require outstanding charges to be paid as a condition for the continuation of supply. And note also there's a temporary carve-out in the case of coronavirus stroke during the relevant period for small suppliers, measured by a combination of criteria including turnover and balance sheet and number of employees. Simon, thank you. That concludes my my first part. Let me hand over now to you on winding up petitions.
Thank you, Stefan. So as Stefan has indicated, the permanent measures in the bill have had a very long gestation, but perhaps inevitably the new temporary measures, which are designed to deal with the effects of coronavirus pandemic, have been more reactive. And so to an extent, we're grasping our way in the dark as to how they will interact and work in practice. The first real hint that the government intended to introduce restrictions on winding up orders came on the 23rd of April, when it published the statement which is on the screen, and which suggested that there would be a temporary ban on landlords serving statutory demands and winding up petitions on tenants in respect of unpaid rent. 2 days later, the statement was amended to put a bit of flesh on the bones and indicate that the ban on statutory demands would apply for the period 1st March to 30th of June, and the ban on winding up petitions would apply to the period 27th of April to 30th of June. And what was added to the statement was a note to editors, which is the second quote on the slide, which suggested that the court must review the reasons for a debtor company's inability to pay before making a winding up order. 2 days on from that, on the 27th of April, Mr. Justice Snowden handed down judgment in the Short Gardens case. This was an application to restrain the presentation of winding up petitions which were based on unpaid liability orders in respect of non-domestic rates and some unpaid costs orders. One of the grounds on which the application was made was that the ministerial statements which we've just seen indicated that the government intended to ban winding up petitions against any company who was in financial difficulties as a result of the COVID-19 crisis. On the facts of the case, Mr. Justice Snowden was not satisfied that there was in fact any evidence to show that the companies in question were unable to pay the petition debt because of COVID-19. But it's interesting to note, I put the relevant slide up, relevant quote up on the slide, that the learned judge took the view that it was overwhelmingly likely that any restriction of winding up petitions to be introduced in the bill would be limited to companies in specific sectors, such as retail or hospitality, and would relate only to claims by landlords for rental arrears. Now, of course, at that stage, the draft bill had not been published. And in fact, as we'll come to see, the provisions in the bill relating to winding up petitions, which you can find in Schedule 10, are not limited by reference to sector or by type of debt. They apply to all companies. There are some provisions which will apply with retrospective effect, and there are some which will apply prospectively from the date in which the schedule is enacted. I'm going to deal firstly with the retrospective measures, which will be effective from the 27th of April. That is the date that the government flagged up in its ministerial statement. So first, paragraph 1 of Schedule 10 imposes a blanket ban on winding up petitions which are based on non-compliance with a statutory demand which was served on or after the 1st of March. So this only applies to winding up petitions presented after the key date of the 27th of April. What that means, therefore, is that if a winding up petition has been presented before the 27th of April and it's based on a statutory demand after the 1st of March, that's not invalid. There is no blanket ban on winding up petitions which are based on statutory demands served before the 1st of March, nor is there a blanket ban on a winding up petition which is based on one of the other grounds in section 123. So that's to say unsatisfied execution or an assertion that the company is unable to pay its debts as it falls due, or an assertion that the company is balance sheet insolvent. But paragraph 2 of Schedule 10 provides that a creditor may not present a winding up petition on any of those grounds unless that creditor has reasonable grounds for believing that one of two conditions are met. And paragraph 5 then goes on to say that the court cannot make a winding up order unless it's satisfied that one of those conditions is met. And this may loosely be dubbed as the coronavirus test. And I understand that when the new temporary insolvency practice direction, which will address winding up petitions in the current climate, comes into force, that is the term that will be used to describe this. And turning then to look at what I've described as the coronavirus test, it's essentially twofold. So the first condition is that coronavirus has not had a financial effect on the company. And paragraph 21, subparagraph 3 explains that this means that the company's financial position has not worsened in consequence of or for reasons relating to coronavirus. And clearly that's going to be an extremely difficult condition to satisfy in most cases, because it's likely in respect of almost all companies facing financial difficulties that coronavirus will have had some worsening effect upon them. The second condition essentially is that the ground for seeking the winding up order would have applied irrespective of whether or not coronavirus pandemic had happened. And it's that second condition which I suggest is going to be the more fertile ground for argument moving forward. And it's clearly designed to ensure that the restriction on winding up petitions is limited to those companies which have been affected by coronavirus to an extent that they're now insolvent, and doesn't lead to simply a blanket ban on winding up petitions against all companies. Now, because the coronavirus test will apply from the 27th of April, as I've said, with retrospective effect, it's necessary to have provisions in the bill which deal with winding up petitions which have been presented since that date and winding up orders made since that date, because of course unless and until the bill becomes law, there will be a number of courts that have proceeded on the basis of the law as it currently stood, and no doubt up and down the country, and I suspect particularly in the county courts in the regions, orders will have been made in ignorance of the fact that the bill was forthcoming and may have retrospective effect. Paragraph 4 of the bill, of Schedule 10 of the bill, provides that if the court is satisfied that a creditor who presented a winding up petition on or after the 27th of April did not have reasonable grounds for believing that the coronavirus test was met, then the court may make such order as it thinks fit to restore the position to what it would have been if the petition had not been presented. So in essence, it's a broad discretion on the part of the court to effectively set aside winding up petitions that have been presented after the key date where the coronavirus test is not met. Paragraph 7, subparagraph 2 then goes further and provides that if a winding up order was made on or after the 27th of April, and the order is not one which the court would have made if the coronavirus test applied, then, and now I'm quoting from the relevant paragraph, the court is to be regarded as having had no power to make the order, and accordingly the order is to be regarded as void. What that means in practice, I'm afraid, is that all winding up orders which have been made since the 27th of April are a bit like Schrodinger's cat, because it's impossible to say with any certainty whether or not those winding up orders are valid unless and until the court has considered afresh the question of whether or not the coronavirus test applied at the time, and therefore the question of whether it would have made the winding up order regardless had the act been in force at the time. And for good measure, subparagraph 4 of paragraph 7 of Schedule 10 then provides that the court can give such directions to the official receiver, the liquidator, or any provisional liquidator as it thinks fit for the purpose of restoring the company to the position it was in immediately before the petition was presented. This obviously raises the spectre of what's going to happen in terms of cost orders, because it's likely there will be cases in which, in ignorance of the forthcoming changes, because of course they hadn't yet been announced, petitioners will have sought and obtained winding up orders quite properly on the basis that the debtor company is unable to pay its debts. But now, because of the retrospective effect of the legislation, the court concludes that those orders shouldn't have been made because of the coronavirus test. In consequence, the winding up orders being set aside, and there then being a need for someone to pay not only the official receiver and or liquidator's costs to date, but also potentially the costs of the company in now successfully defending the petition. And whilst it seems grossly unfair, it strikes me at first blush that if this is treated as analogous to the position in terms of rescissions or successful appeals against winding up orders, that those costs may end up lying at the feet of the petitioning creditor, which is slightly invidious in circumstances where that creditor may well be insolvent itself or suffering cash flow difficulties as an impact of the failure of the debtor company to pay. But certainly there's nothing in the bill that expressly addresses that, and that's something which practitioners will need to be alive to. That deals with the retrospective amendments. There are then further amendments which will come into force when the schedule is enacted. The first of those is located in subparagraph 3 of paragraph 19 of Schedule 10, and that amends the insolvency rules to require the petition to include a statement that the petitioner considers that the coronavirus test is met. And Stefan, I think this is something which you've had to advise on recently.
Simon, yes, thank you. Even though the Act is not yet in force, I have been involved in a case where very presciently my instructing solicitor took the view that actually the appropriate thing to do in the witness statement was to include a statement to the effect that the coronavirus test had been satisfied. It was a very short statement, and it was modelled along the lines of the statement that we're all used to seeing in relation to the EU regulation as to whether it's going to be main proceedings or secondary proceedings.
That's very helpful, Stefan. Lisa Bricknell has posed a question in the chat, which I can usefully deal with now while we're on the point, which is to ask, are you aware of any applications by ORs or liquidators relating to the avoidance of winding up orders made since the 27th of April? The short answer is no. And the reason is, of course, because at the moment the bill is not yet law. So whilst it's extremely likely that when it's enacted, those winding up orders will be void, at the moment they, strictly speaking, on their face are valid because the retrospective impact hasn't yet come in, although I'll touch upon that a little bit more in a minute when I come to look at a couple of recent reported decisions relating to injunctions restraining presentation of petitions. Returning to the key amendments that come into force when the schedule itself comes into force, probably the main one is located in subparagraph 2 of paragraph 19, and that prevents the petitioning creditor from advertising or otherwise giving notice of the petition until such time as the court has made a determination in relation to the question of whether it is likely that the coronavirus test is met. Now, obviously, that's quite wordy, but the short point is, as I'll come on to show, the bill envisages there will now be a new intermediary stage where the court has to, as an almost filtration exercise, decide whether it thinks it's likely that the coronavirus test is met, and only if it is does it then permit the petition to be advertised. And as an adjunct to that, subparagraph 4 also prevents the court file from being inspected without the permission of the court until that time. Now, this will, as I say, fundamentally alter the procedure in relation to winding up petitions, and it might be useful to consider how this affects the timeline from presentation of petition to final hearing. Although before we come to presentation of petition, there's of course an intermediary step. It's logical to start with the pre-petition stage, because it's always, of course, been possible to apply for an injunction to restrain the presentation of a petition on the grounds that the petition will amount to an abusive process. And usually that's, of course, either because it's said that the petition debt is genuinely disputed on substantial grounds, or the debtor company has a genuine and substantial cross-claim which equals or exceeds the petition debt, so that when the two are set off, there's no net debt owed to the creditor and therefore no insolvency. It would appear that it will now be possible to apply for an injunction pre-petition on the basis that the coronavirus test cannot be met. The case I mentioned a moment ago, Short's Gardens, was an example of an unsuccessful application to restrain the presentation of a petition, but there have been two recent cases, very recent cases, in which applications have been successful. They are the two cases on the slide: the Travelodge Limited matter and the Rear Company matter. First, a decision of Mr. Justice Burse, the second, a decision of Mr. Justice Morgan. In both of those cases, the debtor companies applied for injunctions on the grounds that the petition was bound to fail for two reasons. First, the coronavirus test would not be met because the companies, both of which were in the retail sector or hospitality sector, had suffered financial difficulties because of the blanket shutdown on those industries as a result of coronavirus. And secondly, it was also said that the petition was adverse to the interests of the creditors as a class because those companies wished to pursue restructuring plans which would have been unachievable if the company entered insolvent administration or insolvent liquidation. Both of those applications were made in the applications list on an ex parte basis, although in both cases the petitioning creditor appears to have been given some notice and indeed to have instructed solicitors to attend. Formal representations weren't made on their behalf, so it was treated as essentially a one-sided hearing. And because it was therefore ex parte, the question for the judge in each case was whether the applicants had a strong prima facie case. And in both cases, the judges were satisfied that there was a strong prima facie case. And so what they did was to grant temporary interim injunctions, which were then listed for a return date for a fully contested hearing to consider afresh the question of whether or not the petition was bound to fail. And in the latter case, just worth noting that Mr. Justice Morgan held that the applicant company should give a cross undertaking in damages. Now, that seems a slightly curious decision and seems to cut across the general prevailing practice in insolvency matters when it comes to obtaining temporary injunctions to restrain advertisement of petitions, because of course it's very difficult to see how it could be said that a petitioning creditor could suffer loss or damage as a result of being prevented from obtaining a winding up order against a company, given that the winding up order is a class remedy. But nevertheless, it's worth reflecting on the fact that there's a possibility for the court to consider or assess this coronavirus test before a petition comes into fruition. Of course, once the petition has been presented, then the company normally can apply for an injunction to restrain advertisement and further proceedings, and that application is usually made on the same grounds as the application to restrain presentation, that is to say that there's a genuine dispute or a cross-claim. Now, of course, because of the new amendments which prevent advertisement of a petition until the court's made its determination of whether it's likely that the test is met, and also the ancillary amendments to prevent the court file from being inspected, there's no longer any need to apply to restrain advertisement. But it's still, of course, possible to make an application for an injunction injuncting further proceedings and in effect striking out the petition. And if such an application were made, I would suggest that would amount to effectively an expedited hearing of the petition, because then the court would have to decide whether or not the coronavirus test is actually met. And no doubt when the two temporary injunctions granted in the Travelodge and the Rear Company cases come back on for their return date, the judges hearing the return date will have to consider whether the coronavirus test is satisfied. But as I mentioned a moment ago, the bill in fact envisages that there will be an intermediary stage, which is perhaps a slightly lower test, where the court considers whether it's likely that the coronavirus test is met. Now, as I say, that must clearly be a lower test than the question of whether the coronavirus test is met, because whether or not it's likely is different from whether it's satisfied. There is a question mark as to how much lower that test is, though, because on applications to appoint provisional liquidators, the test the court applies is whether it's likely that a winding up order will be made. And that usually involves the court, in essence, carrying out the same exercise that it would carry out in determining whether or not the winding up order should be made. Whereas it appears that what Parliament had in mind, in fact, was that this intermediary stage was more of a filtration mechanism, perhaps akin to what happens with applications to set aside statutory demands in the bankruptcy context, where the court looks at the application on paper, and if it's clear on its face that the application is unmeritorious, then it dismisses it. If it's not clear it's unmeritorious, it lists it for contested hearing. So it seems to me that probably the court will be able to do an initial paper consideration of a petition, look at the reasons given by the petitioner for suggesting that the coronavirus test is met. If it's clear that that's wrong, then the court can presumably dismiss the petition out of hand then. But if it's not obvious, there will presumably need to be a contested hearing, at which the court will then hear argument as to whether or not it's likely that the coronavirus test will be satisfied. If the court's happy it is likely, then the petitioner will be allowed to go ahead and advertise, but then there'll still need to be a hearing of the petition. And it strikes me that as well as then arguing the toss as to whether or not the supposed grounds for winding up are made out, you know, for example, is the debt disputed or not, is there a cross-claim, the court will have to consider afresh the question of whether the coronavirus test is met, because at the final hearing stage, it's not a question of whether it's likely the test is met, but whether it's actually met. So it seems that the company will probably be entitled to 2 bites of the cherry, arguing at the preliminary stage it's not likely it's met, then re-arguing at the final stage on the higher degree of scrutiny that it's not met. Although in practice, I wonder how many judges would be happy to find there already having been a determination that the test is likely to be satisfied, that it's nevertheless not satisfied. The final series of amendments which have been brought about by the bill, or will be brought about when it comes into law, concerns the situation where a winding up order is made on a petition which has been presented since the 27th of April. So this is assuming a case in which winding up order is properly made, so the coronavirus test is satisfied. But as you'll be aware, Section 129 of the Insolvency Act provides that winding up is deemed to commence on the presentation of the winding up petition. But this is amended in respect of petitions presented after the 27th of April by paragraph 9 of Schedule 10 of the bill, which provides that winding up will be deemed to commence on the making of the order. And the consequence of that is that Section 127 of the Act, which provides that post-petition dispositions are automatically void, will not apply. So it prevents the need for there to be any application for validation orders, for example, in the current climate. There are then consequential amendments to the relation back period in various provisions of the Insolvency Act dealing with transaction avoidance to make sure that the twilight period between the presentation of the petition and the making of the order is not a period in which it's impossible to receive relief under any of those sections. And so how that's done is that if the winding up order is made less than 6 months after the presentation of the petition, then the relevant relation back period is calculated by reference to the presentation of the petition. But if more than 6 months elapses between the presentation of the petition and the making of the order, then the relation back period is calculated by reference to the making of the winding up order. But in either case, the period runs up until the making of the order, not as it would otherwise be the presentation of the petition. And for the sake of completeness, I've set out on this slide here the different provisions which will have to be modified so that the relation back period applies for the entire period up to winding up. Probably the most relevant for present purposes is Section 240, which sets out what the relevant time is for transaction undervalues and preference claims. So the upshot of this in practical terms is that whereas before the amendments the bill will bring into force, any dispositions entered into after the presentation of the petition are automatically void, in the absence of a validation order. Now, those transactions will be valid, but it will be possible to challenge those as transactions to undervalue and or as preferences, assuming that they were not for full value and or they did amount to factual preferences with the intention of preferring particular creditors. That then addresses the new amendments dealing with winding up petitions. I'm now going to hand over to Govinder, who's going to look at the wrongful trading provisions.
Thank you, Simon. Now, as Stefan mentioned earlier on, one of the temporary measures which we now have is the suspension of liability for wrongful trading. And if we start with the rationale behind the suspension, and just to paraphrase slightly what the explanatory notes say, we see that the purpose is to allow directors of companies, importantly, which are impacted by the pandemic, to be able to make decisions about the future of the company without the threat of becoming personally liable to personally contribute towards the company's assets in the event it later goes into liquidation or administration, as the case may be. Now, before I go on to explain my views on the draft legislation and the impact which it might have for creditors, debtors and office holders, I think it's important to look at how Section 214 actually operates. So on the next slide, as we can see here, the court has a discretion to declare that a director is liable to contribute towards the assets of a company when at some time before the commencement of the winding up, the director knew or ought to have concluded that there was no reasonable prospect of avoiding an insolvent liquidation or an insolvent administration, as the case may be. Now, just some very brief observations on Section 214. Primarily, Section 214 is concerned with losses caused to the company, not the creditors, and what must be shown is a net deficiency in the company's asset position. Section 214 is an office holder action, which inures for the benefit of unsecured creditors, and so the fruits of any successful action won't be caught by any charge which the company is granted. And of course, there must be a critical date by which the director knows or ought to have concluded the matters which I referred to just a moment ago. So let's have a look at the new measures, and the important parts I've highlighted in bold. And effectively, the court is to assume that the person is not responsible for any worsening of the financial position of the company or its creditors that occurs during the relevant period. And we see that the relevant period is the 1st of March 2020 and ends with the 30th of June 2020, or of course 1 month after the coming into force of the Act, whichever is the later. So just some observations on how this is actually going to operate. We see that really what the suspension does is that it limits the extent or quantum of any contribution which a director might be ordered to make. And so it's clear that losses incurred during the relevant period, those won't be taken into account. But the temporal limits, which are manifest in the relevant period, mean that it may still be the case that a director is required to contribute for any losses caused to the company, but that would be where the wrongful trading occurred outside the relevant period. So take, for instance, a director of a company who has the relevant knowledge for the purposes of Section 214 in February and continues to trade the company from February, say, to May. In my view, whilst he wouldn't be required to contribute towards the assets of the company from March to May, he would be required to make a contribution for any losses caused to the company in February. But on the other hand, we see that where the wrongful trading, if indeed it can be called that, is confined to the relevant period only, then liability is extinguished altogether. And that's my reading of the phrase responsibility. And I think it's also curious that the suspension makes reference to creditors, when, as I mentioned earlier, properly speaking, Section 214 is concerned with losses caused to the company. So now we have an idea of how it works. Let's have a look at what the impact is going to be on directors. Well, we know that at times where the company's solvency position is doubtful, because of this fear of personal liability, directors are less willing to assume new liabilities, and often what might be considered to be the safest course of action is to shut up shop immediately and place the company into an insolvency process. Now, with that fear of personal liability removed, or at least for the relevant period anyway, what we might see is a greater willingness on behalf of directors to perhaps assume new liabilities to keep the company afloat. Now, standing back for just a second, that's a positive for companies that were viable before the pandemic, because those are the companies arguably which should continue. But one of the problems is that the suspension is actually applicable to all eligible companies. So what we might have is unviable companies who were unviable before the pandemic started, who sort of rumble on while supported by lots of debt. And that's a negative for the economy when the pandemic subsides. And there's also practical queries as to how those sorts of loans are going to be obtained, because it seems to me that conventional lenders might be more risk averse about lending on an unsecured basis, which in turn might mean that directors have recourse to alternative providers. And of course, it might mean that there's an increase in the number of personal guarantees to sort of mitigate against the suspension of liability. So in terms of moving forward, on the next slide, we'll see that in terms of the impact on directors, it's not a get out of jail free card. Alex Sharma mentioned that all the checks and balances will remain in place. And so the following measures, which I've put on the slide here, that they still remain applicable. But one of the factors I'll query is how efficacious they will be. So what does this mean for office holders and creditors? Well, on the next slide, we see that the wording of the suspension is that it's an assumption. And an assumption isn't capable of being rebutted, which means that there's no opportunity for the office holder to say the suspension should not apply. And the reason why that's problematic is because, as the explanatory notes to the CIGB say, there's no requirement to show that the company's worsening financial position was due to COVID-19. And so it seems plain, therefore, that there's a lot of potential for abuse. And one has to query whether this marries up nicely with Parliament's intention. As I said at the beginning, that this to allow directors of companies which have been impacted by the pandemic, or using the example I referred to a moment ago about the director who has the relevant knowledge for the purpose of Section 214 in February, arguably he's not somebody, nor is his company, impacted by the pandemic, and yet they still obtain the benefits of the assumption. And recently in the House of Lords, Lord Hope commented on whether the assumption is intended to be rebuttable or not, though he looked at it from the position that a director might be subject to various causes of action. And so it's important we get clarity on this particular point so the director knows where he stands. Just briefly, in terms of what would have been a better way of dealing with it, in my view, and that would be to change the wording from an assumption to a presumption, which of course is capable of being rebutted in an appropriate case. And in my view, that would strike the right balance between ensuring the right companies continue trading and preventing the measures from being abused. And we also see that it perhaps would have been sensible to take on board other parts of the bill, as Simon touched upon, with winding up petitions and the inability to pay being as a result of COVID-19. Now, we come now to directors' duties, and one of the issues I have is whether, even though it's left, whether that's actually going to be an effective safeguard or not, because it strikes me that in the current climate, directors might have a better chance of arguing that continuing to trade was in the interests of creditors. Indeed, I can sort of anticipate an argument on behalf of a director that, well, my company was viable before the pandemic struck. It was better for the creditors for me to wait the crisis out and keep going, as it were, because when the company returned to a state of profitability, the creditors would receive a better return than they would on an insolvent liquidation. They might also point out that the company's position isn't going to get any worse, because by being able to furlough employees, for instance, the company's expenditure is lower. Now, if it is the case that alleging a breach of directors' duties is the route towards recovery, what that might mean is that debenture holders will benefit as a result of the suspension in a way in which they would not if Section 214 had been left. And the reason for that is an action under Section 172 is an asset which belongs to the company, which inures for the benefits of, in the first instance, of charge holders. Now, we now come to the Company Directors Disqualification Act, and again, we know that that measure has been left in place. And it strikes me that the most interesting question is whether the Secretary of State can effectively sidestep the suspension and seek compensation for losses incurred during the relevant period. And just to back up a second in terms of how we get to that question, we know that the Small Business and Enterprise and Employment Act introduced the concept of compensation orders, which are now contained in section 15A to C of the Company Directors Disqualification Act. And we know that the general effect is that the Secretary of State can obtain compensation. Now, it's a freestanding regime, and unlike section 214, the liability is based on losses caused to creditors as opposed towards the company. Now, there are two hurdles that have to be jumped before an order granting compensation is made. Firstly, the person has to have been made subject to a disqualification order or have given a disqualification undertaking. And conduct which the person is subject to the order must have caused loss to one or more creditors of an insolvent company. So, moving on to the next slide, we know that under section 10 of the Company Directors Disqualification Act, if the court makes a declaration that the director concerned is liable to contribute towards the assets of the company pursuant to section 214 of the Insolvency Act, we know that the court can then go on to seek disqualification of that director. And of course, this can be something that can be consolidated in proceedings, say, for instance, with the official receiver and the liquidator of a company. Now, it strikes me that if the wrongful trading has occurred only throughout the relevant period, then the court won't have made the relevant declaration, and so it won't go on to consider disqualification, and so the question of compensation is never triggered. But if part of the wrongful trading occurs outside the relevant period, and if losses have been caused to creditors, then it follows that the relevant declaration will have been made, disqualification is in theory possible, which lastly triggers the compensation regime. And of course, the million-dollar question is, will this include losses incurred during the relevant period? Now, some of the arguments are these. An argument 4 is effectively that clause 10 could only have suspended the liability to contribute towards the company's assets, but it can't have suspended the liability to make good any losses which are suffered by creditors, because properly speaking, section 214 is not concerned with that. And so on that argument, the suspension of liability should not prejudice the ability of the Secretary of State to seek redress for creditors directly for losses caused during the relevant period. But on the flip side, I can imagine an argument against that is that the only misconduct is in fact matters outside the relevant period. And so it's only losses which flow from that misconduct which are actually compensable. And I think the counter argument to that would be that it's sufficient that the court has made a finding of misconduct, i.e. outside the relevant period. And so it's artificial and unrealistic to describe what's effectively the same conduct as attracting no liability. I also envision there might be some sort of policy-based argument along the lines of, well, a director should not be in a better position if he is guilty of wrongful trading outside the relevant period as a result of the suspension. Now, of course, whether or if at all this issue is brought, it's difficult to say what the answer will be, but it strikes me that the outcome will no doubt be policy-based. And I can see a court perhaps looking at the matter broadly and saying, well, this suspension was designed to relieve directors of liability, and it seems to undermine that suspension if the Secretary of State can effectively obtain what the creditors would be after through the back door. But on the other hand, I am attracted to the idea that if the suspension could never have covered liability to make good any losses caused to creditors. And so that leaves us with the remaining options. And it strikes me that if wrongful trading isn't available, say, because the wrongful trading occurred throughout the relevant period, that might not be the end of the matter, because you might be able to argue that the director concerned was trading whilst insolvent with no reasonable prospect of paying creditors. Now, fundamentally, whilst it's highly similar, but that's not the same as section 214. The courts apply a lower test, or a different test, I should say, which assesses the director's conduct in the round. And it does, of course, constitute a ground of unfitness by which a director might be disqualified. And if, as I say, if a director is disqualified, then the compensation regime is triggered. But on balance, and in my view, I think a court is going to be unlikely to disqualify a director in the current climate. I think it's going to be alive to the fact that we've got a suspension in place which is designed to prevent a director from becoming liable for conduct of exactly that kind. And so, whilst it remains to be seen, I can see a court perhaps being slow to disqualify a director. And that brings us to the conclusion on the suspension of liability for wrongful trading. In my view, the suspension is fair and logical and correct in principle. In the current period of economic turbulence, directors, one might argue, shouldn't be penalised for being unable to appreciate risks which they're unable to evaluate fully. But I'm afraid, as is often the case, ideas are much better than the way in which they're executed. And it seems to me that the legislation, or the proposed legislation, needs to strike a fairer balance between ensuring the right companies continue trading and the companies for whom it is best that they enter an insolvency process, that they do so at the right time, as well as mitigating the potential risk of abuse. I think we're certainly likely to have interesting questions on how the suspension is going to work alongside the Company Director Disqualification Act. And as I say, whilst the efficacy of the safeguards should not be taken for granted in the current climate, but that should not be treated as an incitement to stop observing those duties. Now, that's everything from me on the suspension of wrongful trading. I'm going to pass back over to Stefan, and of course, if there are any questions at the end, I'll happily look at them.
Govinder, thank you very much. We come now to the delegated and Henry VIII powers, and I can be relatively brief on this. As you will see from the next slide, Henry VIII clauses are clauses in a bill that enable ministers to amend or repeal provisions in an act of parliament using secondary legislation. And of course, that's subject to varying but usually less degrees of parliamentary scrutiny. One criticism of these clauses is that they transfer rulemaking powers from the legislature to the executive. So in that sense, they are quite a powerful tool. As applied to the coronavirus bill, the Secretary of State's powers are, certainly in my view, very wide-ranging. They include the ability to amend by statutory instrument corporate insolvency or governance legislation, and more specifically, amendments can touch on the conditions for entry into an insolvency process, alter the manner in which the process applies to any given entity, and perhaps even more significantly, change or disapply duties or liabilities of a person with corporate responsibility. So these are really quite key and important matters. However, the powers are subject to various restrictions and safeguards, as the next and final slide makes clear. The regulations can only be made if the Secretary of State is satisfied that they are expedient in the light of the current coronavirus pandemic. The amendments to be made have to be proportionate to the purposes sought to be achieved, and that the same has to be done by legislation. There is also a time limit on regulations, i.e. 6 months. Now, it might be said, why include this power in the bill if it wasn't the intention to make those sorts of amendments at all? Of course, we don't know what the government has in mind, but it's fair to say that there are likely to be, as I've already said, unanswered questions, some of which Sam will touch on next week, which might require amendments by statutory instruments. All we can say at this stage is, certainly when advising clients over the next couple of months, it's very important not just to see what the status of the bill is, but also any regulations or statutory instruments which have been made following the entry into force of this bill. As I put it at the bottom of the slide, watch this space. That concludes part one of the webinar. Simon, let me hand back to you. And I think in the past we've sort of stayed online for a few minutes to see if anybody has any burning questions that they want to ask, either live or by the chat function.
Thank you, Stefan. I don't think we've had any questions unanswered in the chat function, but if anyone does have anything they want to raise, then feel free either to type something in the chat or turn on your microphones and ask away. Or alternatively, if either you have a burning question that occurs to you after this or just need to get away, then by all means feel free to drop a line to any of us by email, and we'll do our best to answer them. We'll remain here for the next 5 minutes or so just to give people an opportunity to raise questions they want to. But if not, thank you very much for attending, and we hope to see a lot of you again next week in part 2. So Ed Sabers asked, are there in your view likely to be any amendments from the Lords? Well, I think all three of us rather sadly endeavoured to do our best to watch at least some of the debates taking place yesterday afternoon, and I think the indication was that there are at least a few matters where the Lords are going to suggest amendments. Whether or not they survive the return to the Commons is another matter, but certainly I think, Govinder, you alluded, for example, to Lord Hope's discussions of wrongful trading.
Yes, it was certainly put for discussion about whether the assumption is going to be rebuttable or not, and so one hopes it'll be taken into account, but at present one's also unable to say anything further. But it's just one of those points that just remains to be seen, I think.
Penny's asked, how are the court's resources for dealing with the new legislation? And I think pretty much the same answer as the court's resources generally, which is, as you can imagine, the roles building are all over the new legislation, and I think to an extent have had a weathered eye on some of the drafting as it's gone through. And as I mentioned earlier, I'm aware that we can expect a new temporary insolvency practice direction pretty much as soon as the bill becomes law, which will set out procedurally how certainly the courts and the roles building are going to be dealing with matters there. I suspect it will take quite some time for that to filter its way down to the county courts and some of the regional hubs. And one can readily foresee that there's likely to be a large number of cases that are going to have to go back to the court to determine the status of. And given that we're having difficulties with listing of things remotely in the regions at the moment anyway, because of the massive backlog of things that have been adjourned off, I think it's fair to say that we can expect there to be quite a long tail in terms of the lag of cases working their way through. Stefan, this is one for you, I think, from Elizabeth Taylor, which is which debts will be subject to a payment holiday for the purpose of the moratorium?
Simon, yeah, thank you. So I think it's pretty much all debts subject to exceptions, and the exceptions which are currently set out in the bill are those that I touched upon a little earlier in the talk. So, for example, the monitor, it is likely, will be retained by the relevant company. The monitor will incur fees. And that, of course, will create a debt from the company's perspective, and that is a debt which it will not attract a payment holiday. Other examples are ongoing rent, wages or salary, and goods or services supplied during the course of the moratorium. But there is a fairly detailed list in the bill as it currently stands. But we'll have to wait and see what comes of the passage of the bill through the House of Lords and the House of Commons.
I think that feeds quite nicely back into Ed's question, because from recollection, this was one of the topics that was raised by one of the Lords in terms of potential amendments and as to whether certain things should have payment holiday priority. Nigel Whitfield has asked, will we be emailing the slides? And I think the short answer is yes, we can arrange for that to be done. We'll also have recorded this webinar, so it will be available on the Chambers YouTube channel in due course as well. David Pomeroy has asked, do you have a view on section 1157 and COVID? Which I suspect, Govinder, is probably one to throw over to you, given it fits in nicely with your discussion of the wrongful trading provisions.
Well, we know that section 1157 doesn't have any effect on the wrongful trading provisions. It doesn't require any finding of dishonesty or anything like that. But I think in terms generally speaking of directors' duties, I think it does filter in nicely into how court may have possibly more sympathy with a director when analysing his actions in light of the current climate. Those would be my view. I don't know if you've got anything to add to that, Simon.
I think all I would say is that it strikes me that obviously Section 1157 relief only comes into play at the point where the court has determined there's been a breach of fiduciary duty.
Mhm.
I suspect that it's going to be easier for judges to find that there's been no breach.
Mm.
If what's being alleged, for example, is a breach of the duty to act in the best interest of the company and the creditors,
Yeah.
well, it's going to be easy to find that in light of COVID, the directors have exercised their duties properly so that it doesn't come into play. It'll be a strange case in which there's been found to be a breach of that duty, for example, but nevertheless the directors acted honestly and reasonably. But one can see that if there's a technical breach of one of the guidelines, it may be a runner. Ed has asked, do you think that the imposition of the super priority for moratorium debts will create a significant hindrance in subsequent insolvency processes, lack of assets for costs, other creditors? And I could slightly cheekily say, well, no doubt Sam will be answering that in part 2 and leave it to that. But Stefan, I don't know if you've got any views on that in the meantime.
Well, I think my reaction to Ed's question is yes, possibly. Having said that, I don't think one can overlook the fact that the moratorium is designed to be for quite a short period of time. So one would like to think that the super priority will be in respect of a hopefully limited number of debts, but I think it'll have to be very much on a case-by-case scenario that one assesses that.
Neil Howard has asked, what about out-of-court hours filings and moratoriums? If the courts adopt the temporary insolvency practice direction approach to administration, that's to say that something filed out of office will be treated as received at 10 o'clock on the next court business day, then this could lead to a delay in up to 66 hours for filing on Friday at just after 4 o'clock on a Friday, with implications for demarcation between pre-moratorium debts and those entitled to super priority. I suspect the short answer is, again, that if you have an urgent need to file out of the court hours, then you'd be best advised to be making an application to an emergency judge to bless it anyway, rather than taking the risk. But Stefan, I'm certainly not aware of this being a point that's currently yet been considered by the bill.
No, I agree, and I think this is it's an excellent question, if I may say so, and I think it's one that we'll need to see how the practice direction looks once this bill has passed, and what provision is made in that practice direction for out-of-court filings for the moratorium. Given the amount of interest that has been generated by out-of-court administration filings, I would have thought it's very likely that this is something which will be covered off in any practice direction, but it's a case of wait and see.
Well, I should add that my understanding is that there's proposed to be 2 new practice directions. So we've got the temporary practice direction that was introduced immediately after the coronavirus pandemic hit, and that was a useful opportunity, as well as adjourning off hearings for a temporary period, to sneak in a provision tidying up the difficulties that the whole line of authorities, I think there's been 11 reported decisions on out-of-hours filing of administrations, were designed to deal with. There are going to be 2 new ones, as I say. One is going to deal specifically with the procedure in terms of winding up petitions, and I've seen some of the advanced drafting of that, and that's in a good shape to hit the presses, I think, pretty much as soon as the act comes into place. The second one will be dealing specifically with the new permanent insolvency regimes, and Sam Parsons has just made a point that the priority of moratorium debts has a parallel with so-called dip lending under Chapter 11. It's an incentive to enable new debt to be injected into the distressed company. How that would translate in this jurisdiction is a point that will be explored next week. So there we are. That's some good publicity there, Sam. We'll find out the answer next week, no doubt. But just to finish the thought, yes, I think there's going to have to be a specific dedicated practice direction dealing with these points, and if it's not at the forefront of the minds of those drafting that practice direction, then no doubt it will be something that we communicate to them in due course, because it is a fairly critical matter.